good afternoon, even to my YouTube channel. Let's get into a new topic because they claim in certain states marijuana is legal or illegal. So does the question for them, does the Supreme Court have Supreme Court of somebody who declares their nationality? Not only that, having writing that they're not the creator, and even if they say they're higher than the creator, they can't tell you what to put in or out of your body. That's called compellment, correct? Involuntary or involuntary, same difference. Now, the first term I'm going to get into the law term is abatementum, is Latin in Old English, freehold of the lands, imposition by the death of an ancestor, and the entry of the heir, which is considered bloodline. So, does their bloodline permit these people or from owning property, land, gold, silver, and businesses of their own in a free Moorish national name? Absolutely not. Now let's go into this, what it says on this website about marijuana, because they know long before marijuana was established and forbidden by these so-called 13 states, which represent the sun and the moon cycles. 13 and 13, 3 and 3 is 6, 1 and 1 is 2. So based on the female calendar, it is 2 days short of 30 days. It says in Alabama is mixed conflict of interest of mixed, whether it's medicinal and the state laws of marijuana. That's what it says. But statute, code, and resolution, is it any does that have anything to do with the actual law, which is all law? Absolutely not. Now let's get into some Latin law dictionary. Sixth edition, Black Laws Dictionary. Since they want to claim, oh, it's the lower self, it's the devil, boogie boogie. Ab anito mundum, from the beginning of the world to this day. Therefore, if they claim the indigenous people who are the Moorish Americans, Moors and Muslims of this land can't own land, this is in fact false in property. And it also says in the law dictionary, able to earn, which means creating a business in a free Moorish national name. It says in Laws Dictionary, Black Laws Dictionary 6, ability to obtain and hold employment, either unable to perform the usual duties of employment under consideration, such as performed by average person, engage in such appointment. It says Kin- Kenyon versus Kenyon 230 MOAPP 71S2D 7882. See also disability, gainful employment or occupation. It also says aboriginal type. There's a difference between aboriginal and original. The Moors and Muslims, and Moorish Americans and Muslims of this land, as in we the people, are aboriginal and original. Such titles, original, aboriginal, natives of the United States, exclusive right to occupy lands, water, and their ancestors before asserted sovereignty over areas. It says Youngton's Sioux Tribe of Indians versus State SD 796 F2D 241243. And nationality is the order of the day. So sovereign is business, how you compete in commerce. So if you if you make your own businesses and you're free Moorish nationally, aren't they supposed to pay you for that? Of course. It's a courting process on my YouTube channel. Absolute law, the true and proper law of nature, immutable in obstruction, in principle, in the theory, but not in application. For often the reason, situations, circumstances exercise an obligation. See also natural law. Still recording in process. Disregard that. It's my YouTube channel. Consider a skill. You say don't teach law and history separate. I am not doing that. Account. It says a detail of mutual demands in the nature of debit and credit between parties arising out of contract fiduciary relation. A statement in writing of debits and credits, of receipts, payments, lists and debits and credits with respective dates. A statement of punctuatory transactions, a record of business dealings between parties, a list of monetary transactions such as losses, sales, debits, credits, accounts payable, receivable, etc., showing a balance, a comparison of the opposite nature. Therefore, is a difference between asset and liability. Therefore, you can even claim your nationality in a financial institution, if they want to call it that. acto empty, an action employed in behalf of a buyer to compel a seller to perform his obligations or pay compensation, also enforce special agreements embodied in the contract of sale. See specific performance. But that is not a contract on agreeable terms. Therefore, it can be renegotiated. Also, in Black Law's Dictionary, actionable misrepresentation, a false statement respecting a fact material to this contract and which is influential to producing it. See fraud, misrepresentation. It says actual authority. It says the power of an agent to bind its principle derives from express or implied agreement between the principal and the agent. So if you declare your nationality as an agent, which they say is the actual authority, and the principal, where does that leave in jurisprudence? The power of your own agency? Correct. In the law of agency, such as principal intentional confers an agent intentionally or ordinary care allows the agent to believe to himself to possess. It says National Cash Register Code versus Wichita, which is Washita, frozen food lockers, Texas Civil Law, APP 172, Southwest 2nd Edition, 781 787. Includes both express and implied. So they imply this. So if they imply this, means they even if they do know or don't know, ignorance of the law is no excuse. It says adequate remedy. At remedy at law for the purpose that a litigant who fails to avail himself remedy provided by the law subsequently bared for pursuing the remedy of his own lack of due diligence cannot rely on the absence of a remedy at law for equitable jurisdiction, practicable as efficient at the ends of justice in the prompt administration in equity, which is obtainable as a right. Which means they're telling the people not only to declare the nationality, they have to pay for their knowledge as well. In Re Wife K. Del CH297 A2D 424426.